Welcome to ADT's Sharda Bai Pawar Mahila Arts Commerce Science College Sharda Nagar Baramati. I am Professor Poonam Mishra. Brought for you subject Secretarial Practice, in which we are learning chapter number 4, Issue of Debentures. Students, in last video we had started the chapter number 4 from your SP subject, in which we saw that what are the rules and procedures and provision for the issue of debentures, for which the Companies Act, Companies Rule 2014 and SEBI rule has to be followed by all the companies. So let's go in the detail and learn what are the provision for the issue of debenture as per the Companies Act. You know, the Companies Act is an act which is passed specially for managing and running and keeping control on the affairs of the company. So the following are the some of the provisions of the act. Provisions means already I have told you student, rules. Okay, so the following are the some of the provisions of the act which a company has to comply, means the company has to fulfill or complete. We can say comply means the word you will remember, complete. Okay students, so the company has to complete while issuing the debenture. The first one is no voting rights. Okay, so the first provision says of the Companies Act for issuing debenture, if a company is issuing debenture to the any person, that person will not have any voting rights in the management of the company. So a company cannot issue the debenture with the voting rights, means they have to issue the debenture without voting rights. Debenture holder are the creditors of the company because they provide loan or debt capital to the company, so they do not have any voting right except in matter which is affecting their interest. Okay, so apart from their interest, apart from their matter, debenture holders are not allowed to vote in any discussion or decision of the meeting or company's decision. Types of debenture. So Companies Act says that a company can issue secured or unsecured debenture. Secured debenture means student on which the asset is mortgaged, or we can say the charge is created on the assets, means any specific asset of that company will be charged or will be saved or kept aside for the payment of that debenture if the company is going to be wound up or the company is in not a position to pay back the amount. So at that time that asset of a company would be sold and amount will be paid to debenture holder. Unsecured means opposite of secured, in which no any charge of the asset will be given. Okay, so in secured the charge of asset will be given, and in unsecured no charge will be given for the asset. So debentures and fully or partly convertible debenture. So Companies Act says that company can issue either of any type of debenture, whether it is secured or unsecured. Fully paid up or partly paid up means they can demand all the amount at the time of subscription of debenture. Otherwise they can demand part of the amount and part will be called by next in the future, further in the future. So to issue the convertible debenture, a special resolution has to be passed in the GM, that is general meeting. Yes, what do you mean by? You already have learned the types of debenture. In that you have seen that convertible debenture will be converted into equity shares after specific period of time or after the maturity date. So if the company has issued the convertible debenture, special resolution, special decision must be passed for that. All debenture are redeemable in nature, and now it is compulsory for all type of organization that they should issue the redeemable debenture. So payment of interest and redemption. So Companies Act says that a company shall redeem means pay back Okay, the company shall pay back the debenture and pay the interest as per the terms of condition of their issue, means whatever was decided at the time of issue. Debenture certificate. Yes, obviously, once the person become the debenture holder of a company, that person should get the debenture certificate. So the company has to issue the debenture certificate to debenture holders within 6 months. So remember this month of the allotment of debenture. Now, the fifth point says that create debenture redemption reserve. Yes, so you know what is journal reserve, students. You already know what is journal reserve. Journal, what is another name for journal reserve? That is retain earning. But this is little bit different from that. Okay, so retain earning and journal reserve are the same, but the debenture redemption reserve, we can say DRR, is not similar to the general reserve, but the feature is one and the same. Why the general reserve is kept by any company for facing any future challenges or sudden loss which is incurred into the business. So that kind of security a debenture holder should get. If any case the company is not performing well, company is in not position to pay back the amount, what the option company is having to pay back the interest and principal amount of the debenture holder. So that's why the company, likewise the journal is a reserve company, keep the DRR, debenture redemption reserve. So the company has to create the debenture redemption reserve account out of the profit. So it is the same process which is for the general reserve. Certain part of the profit will be kept aside in DRR. Okay, so this money can be used only for the redemption of debenture as per the Companies and Debenture Amendment Rule 2019. So MCA has removed the debenture redemption reserve requirement for listed company. So NBFC and housing finance company. So it was compulsory till 2018, but in 2019 it is removed from the listed company which is listed in the stock exchange. Okay, students. So appointment of debenture trustees. So why the debenture trustees are appointed? Let's see. So the Companies Act say that if the company issues the prospectus or invites more than 500 people, either public, either they are inviting to the public or the member of their company, the company has to appoint one or more debenture trustees. So they have to appoint, because the subscriber will exceed to 500 numbers. So for that sake they have to appoint two or one or more debenture trustees. So debenture trustees protect the interest of the debenture. They look after that the decision should be made by the company in the benefit of the debenture holder of the company. So the company has to appoint the trustee by entering into a contract. So one contract will be agreed among the trustee and the company with them, called as a debenture trust deed. So debenture trustees, they are one kind of institution, okay, that protect the interest of debenture holders. That's it. Now the next point says debenture trustees can approach NCLT. Yes, so debenture trustees have to redress the grievances. So grievances has another word, student. The another words for grievances is complaint. So simple word for grievance is complaint, but complaint is a older word, you know it very well, so try to learn the new words, students. Okay, so grievances means complaint, don't forget. Debenture trustee have to redress the complaint of the debenture holder if the company default, means is not able to repay the principal amount on the maturity, or default in paying the interest thereon. The debenture trustee can approach to the company, approaching, if the company is not giving the ultimate solution, so the debenture trustee will go to NCLT. You know who they are. They are the National Company Law Tribunal, who looks after the case or matters related to the company. So NCLT can direct the defaulting company to repay the principal amount with the interest. So grievance means complaint, redressal means remedy or solution or compensation. Now Number 8, impose a restriction. Companies Act says that when the debenture trustee is of the opinion that the assets of the company are insufficient or likely to become insufficient to redeem the principal amount of the debentures. Yes, you know that secured debenture has a charge on the asset, but if the trustee feels that that asset is not sufficient for the repayment of their amount, it may approach to NCLT, or NCLT can order the company to restrict the incurring further liabilities so as to protect the interest of the debenture holder. Yes, sometimes it happens. The company has given the charge on a particular debenture, but further the company has taken the loan from financial institution. So in that situation, that the trustee person can feel that the company is having lots of debt or loan capital, and in that case, if the company will be insolvent or will be insufficient for paying back the amount, at that time the debenture holder will not get their proper amount. So in that case, they can go for the NCLT, National Company Law Tribunal, and they will restrict, or they will stop the company to take further more loans for against the company's asset. So punishment for the contraventions. Contravention means breaking the rule. Provisions means rule. So there should be the punishment for contravention, breaking. Okay, breaking the rules of the Companies Act. So if the company fails to comply with any of the provision of the Companies Act given as under, then the company and its officers shall be liable to pay fine or imprisonment, or the both as prescribed in the act. Hope student you have understood this question. Keep ready your doubt and ask me in the mid session. Thank you.